Kyle Farmer. I'm the owner of Farmer Law PC, and I strategize with employers for solving their labor shortage needs.
Hi, I'm Kiersen Miller, and I'm very happy that Kyle invited us to participate. I'm the COO for Ag Workforce, and we provide solutions to visa employers to support successful programs for them. So I've had history as an H2 employer myself and have sat in your seat, and I'm very passionate about providing solutions and talent and whatever resources we can to make your visa program successful.
Yeah, this is a particularly exciting thing for me because usually I have to sit here and nerd out on H2A stuff alone, but now Kiersen's going to be able to join me. So there are more than one of me in the world where we do get excited about H2 stuff. So these are the topics right here. If you could just in the chat, oh no, whoa, cool, even cooler. Heidi got skills. If you could just vote on the 4 topics that you want us to talk about here, that would be awesome. If you don't vote, I'll pick 4 for you from most confusing to least, because that's the most fun for me. Yeah, so go ahead and put that in here. And then also, just like always, whenever you have questions, put them in the chat, direct them at the host and the panelists, and we'll get to them as we go through. This time we'll kind of get to do it more live though, so that's kind of exciting.
Yeah.
So we'll give you all a second to do that. Oh man, we forgot the Jeopardy music.
Oh no.
That's all right.
There's probably some special copyright issues or something.
Probably. We need to find a good lawyer for that.
I know, right?
Oh man, I tried to vote and it wouldn't let me.
Darn host can't vote.
I know. It ruins it for me. Okie doke. The votes are in. Exciting stuff here. So we've got number 3. What if after certification I need to change my housing? Have you dealt with this one?
I have seen you deal with
Okay,
this
good.
one.
Yeah. Okay. So this is a particularly fun one. God, it's almost like I got to pick these, but I didn't. I swear we actually did use your votes. So you can change your housing under the regulations. The changing of the housing has to be through no fault of the employer. A few years ago, the Department of Labor really didn't care about that portion of the regulations. Over the last maybe year and a half or so, they've started to really care about that part. So the change in the certified housing has to be through no fault of the employer, and the housing that you go to still has to meet the proper regulatory requirements. So let's say that you're in a house, that you have your guys in a house, and lightning strikes the house burns to the ground, guys have nowhere to live. Well, you still have to get the housing inspected and approved by the state workforce agency, and then you have to notify the Department of Labor of the change in housing. So the process is house burns down, worst part of the process. After that, you email the state workforce agency and say, hey, I intend on moving my guys from here to here because the house burned down. Then you notify the Department of Labor, and then the state workforce agency will still schedule an inspection of the new housing for you, and then the Department of Labor will approve the housing. Now, this topic can get complicated, just like we like it. So let's say, for example, that your guys are originally staying in a motel. So under the H2A regs, you're required to provide meals for your workers. So you're providing 3 meals a day. They're staying in a motel. The motel gets infested with bed bugs. They got to close the whole thing down to treat the bed bugs. But conveniently, you did find a apartment down the street that would house all your guys. You can get it inspected and approved. It's got a free and convenient kitchen facility, so you don't have any issues with regards to providing the workers meals. Depending on the language of your job order, which your job order, the language of your job order is extremely important and is something that's awfully neglected. But depending on the language of your job order, so let's say your job order said, "Hey, my guys are staying in this motel. I know I have to provide meals, so I'm providing 3 meals a day." Now we're in the situation where my guys are actually in an apartment with a kitchen. So under ordinary circumstances, I want to be providing meals. However, you are still obligated to provide the meals despite the fact that your guys are now in a housing where you wouldn't ordinarily have to because of the language of your job order. So it's important that if you are moving from one type of certified housing to another type of certified housing, that you still abide by the terms and conditions in the job order. So that's a fun one.
Yeah, I do have a follow-up for you because I know this is something that we worked together on over the last year. We've had employers that had a COVID issue and needed to find a way to set up quarantine housing for people that tested positive for COVID. So in that circumstance, if it's a temporary situation, does that change the procedure in any way?
It doesn't change the procedure. You still need to notify the Department of Labor. You can also notify them, telling them the duration that the guys are going to be in there and why, because we have had that exact thing come up. So 4 of the guys got COVID, 10 of the guys didn't. We don't want to buy each other. Notify the Department of Labor. This is the motel where they're going to be staying. Now, if they're staying in a motel, in theory, you could just get another room. But let's say there are no rooms and they got to go to a different house. You still notify the Department of Labor. This is the reason. COVID's a great reason. The Department of Labor has actually been really good with that justification. So I have to move my guys here. I'm still providing 3 meals a day. State workforce agency, this is where they're staying. Here's the permitting for the motel to demonstrate that the motel meets the proper permitting and inspections, whatever that is. So yeah, that's a good question.
Yeah.
Okay. Does anybody else have any other questions on that one? If you do, you can put them in the chat. Did you have anything else on that one?
No, COVID's the big thing that I've been hearing over the last year and a few months.
Yeah, I've heard that one. I've heard also and sometimes it's things that aren't as complicated, like we intended on leasing that house and then the landlord leases to someone else.
I have heard that too. Yeah, you're right.
Fun stuff. Okay, so what happens if the DOL, the question that came in, what happens if the DOL denies a housing change? So if the housing change, if it's denied by the Department of Labor, then you can't move the guys. But you can also further substantiate the reason for the denial, because usually in the denial, they'll say why it was denied. The employer failed to provide a reason why the change in the housing was through no fault of their own. So you just provide more evidence to substantiate that, whether that's a statement from a landlord or the property owner, a news report, whatever it is. DOL guidelines allow for inspection after occupancy due to COVID. Have you had any experience with this? Yeah, so that would be an example, which if you think about it practically, this would really be the way that it applies, COVID or not COVID. Let's say that the housing burns down. Your guys can't stay in the housing and you're not going to leave them homeless until the DOL comes and inspects the housing. So in all reality, practically speaking, the Department of Labor is going to have a hard time in getting mad about you notifying them of the housing change when it's through no fault of your own, and then the inspection occurs after the guys move in, because that's just logistically how it works. So, but the COVID thing is a great question because it is obviously it's a highly transmissible disease, so you have to get the guys out as fast as possible. So yeah,
absolutely.
Okay, any other questions on that one?
Looked like number 4 was also a popular choice on the poll.
Okay. Yeah.
So we pretty much addressed that.
Yeah,
didn't
that's
we?
so. What happens if what happens? Yeah. So maybe we should get a fifth question or what capture a fifth one here because 4 is going to be kind of the same as 3. What happens if approved housing suddenly becomes unavailable during the work contract? You need to do the things that we just talked about with notifying the Department of Labor and the state workforce agency, getting alternative housing, and really the important reason is for it, or the important thing that you do whenever you're notifying the Department of Labor to remove their subjective ability to deny the housing change is just to substantiate the claim with evidence. Like it's oftentimes not enough you saying, hey, I need to go from this house to this house. It's definitely not enough to tell them I need to go to this house or this house because the rent's cheaper over here. You have to substantiate the reason that you're moving and how that is not your fault, basically.
Number 6 was also popular. Can I deduct workers for damage to the housing? I know that's not a simple answer.
No, it's not.
Very much a case-by-case scenario.
It is. Yeah. So like we were talking about earlier with regards to the importance of your job order. Whenever you get your job order, whether you're filing applications on behalf of people or you're someone that's having applications filed for you, the job order is really important. Read the language on the job order because you want to make sure it actually applies to everything that you would do and captures the types of things that you would want to deduct from the worker's pay. So there's 2 types of deductions in H2 world. Man, this is so fun. This is so fun. We get to just talk. Oh my God. These are all the things I just talked to myself about in the car. So there's 2 types of deductions. There's unlawful deductions and unreasonable deductions. Unlawful deductions are deductions that you would take that are against the law, whether or not they were on a job order. And even if they were approved by the Department of Labor, the Department of Labor doesn't have the discretion to approve unlawful job deductions. Now, damage to a housing does not amount to an unlawful deduction. What would amount to an unlawful deduction is rent, deposits on housing, deposits on sheets and bedding, those sorts of things. That's an unlawful deduction. Even if it was stuck in your job order somewhere, the Department of Labor looked over and approved, it doesn't matter. Unreasonable deductions are those that are not disclosed on your job order, but would otherwise be lawful. So this is a perfect example of that. It is permissible to deduct damage to housing from the responsible worker so long as it was disclosed on the job order. So it's an important thing that you check your job order, make sure it says that you can deduct damage to housing. You can do this to tools and equipment, everything. Now, it does get more complicated than that, which is also exciting. You also cannot deduct from, this is just a rule in general, this is just general employment law. You can't deduct to the extent that it would drop the person's wages below the federal minimum wage. So I'm an H-2A worker. I was going to get paid $1,500 on this check, but I caused $1,300 in damage. So I really get a $200 check for my, 80, 90 hours of work. Then it drops me below the federal minimum wage, and that would be an FLSA violation, therefore unlawful. So whether you disclose it or not in your job order is irrelevant.
One thing, Kyle, that we talk to employers about too, that I think is a gray zone that definitely needs to be looked at case by case and often prompts further investigation is, you talked about the importance of finding out who the responsible employee is. And so if you have 10 people in a shared housing situation and there's damage, what could land someone in a lot of trouble is just spreading out that deduction across 10 people, but not knowing what happened, who did what, and having some way of backing that up if they needed to prove that they had done a reasonable investigation and could identify who that individual was.
That's a great point.
So we've seen where you can't necessarily get to the individual because no one will tell you the story, or sometimes you can. But that's where I think really getting a little bit deeper on the employee relations part of that is essential.
Yeah, that's definitely true. Yeah, and then the other important aspect of that, which you hit on, is documenting.
Absolutely.
Yeah, document why you're making any deduction ever from an H2A person or an employee in general, but definitely with H2A people.
And even the calculation of what you're deducting. So materials, having
Mhm.
receipts to back that up, labor if you had to pay for that for the repair.
Yeah. Now, I guess another important thing, and the reason that is important is because you can't deduct more than the actual cost to repair.
Yeah.
So if I'm a landlord and I'm handy, I'm not, but if I were, and someone broke a window
Mhm.
and I wanted to replace the window myself, I can replace for the cost of the window, but I can't be like, you know what, my time's worth $300 an hour. I'm going to stick that on there. I worked for 4 hours. That's actually $1,200 if you think about it. You
Mhm.
can't do that. It has to be the actual cost of repair. So yeah, the receipts are huge. Okay. Okay. So then, yeah, 5 was also a popular one here, which is good because it's kind of in line with 6. Uh, can I deduct anything from the worker's pay for housing, electric, or water bills? You want that one?
No.
You want me to do it?
The answer is no. But Kyle, what if they take extra long showers?
Sorry.
No.
Yeah, no, you just got really clean H2A guys in that case.
I have seen people monitor the AC or the heat to keep it within a reasonable range from a temperature standpoint. I mean, truly humane and reasonable, not, 90 degrees is when the AC kicks on,
Right.
but keeping it from being set at 60 degrees for the AC to kick on, as an example.
Which is fine. Yeah. Yeah, so that's fine. But in general, the answer to that is no. You don't deduct from the workers' pay for housing, electric, or water bills when they're here on H-2A visas, except for in the event of damage that is properly disclosed, investigated, and documented.
Absolutely.
Okay. Let's see here. So we got 3, 4, 5, 6, and then 10. What tools must I supply to my workers, and what can I deduct from their pay? You want that one, or you want me to do it?
You must supply all the tools to your workers to do their jobs. And as far as what you can deduct from their pay, nothing.
Yeah. Unless they damage those tools and it's properly disclosed, documented, and it disclosed on your job order, documented. And then I guess the other thing is especially with tools, and I think that actually this is actually something probably important that we hit on with tools and with housing, is by damage that does not include ordinary wear and tear.
Yes.
Especially with tools. I mean, because your guys are out there working with whatever, and the lifespan of a hammer is a year, and it breaks after a year. You can't deduct the cost of that. That's just ordinary wear and tear.
I think the other thing, Kyle, is whenever you're looking to make a decision about some of these issues, and you're looking at damage, I like to look at more of a detailed aspect of the scenario. So was the damage negligence? Was the damage intentional? Or, hey, we all make mistakes and we all learned something from this.
Yeah.
So the other thing is you want your employees to want to be there. You want them to stay and not feel like they're in a situation where you don't care about them or their well-being. And you want them to return most likely in future seasons. And so being in a relationship with them where you've got good communication, they understand where that line is, and you're very reasonable about where that line is, makes a big difference.
Yeah, that's definitely true. Let's see here. Okay, cool. Oh, that was all of them. All right.
Yeah. So cool. Our next topic before we get into this specific scenario is to generally talk about how you treat your US workers versus your H-2A workers. And really, I know you'll add some color to this, but the bottom line is the US workers should never be in a negative position because you're an H-2A employer.
You're right. Yep. Yeah. So that's exactly right. It's kind of interesting. So the regulations say that your U.S. workers cannot basically be afforded less, whether it's opportunity, pay, living or working conditions, but it doesn't say anything about more. So you could actually pay your U.S. workers more. Now, one thing that I definitely like to recommend is that you don't do it on the basis of visa versus non-visa,
Yes.
but do it on the basis of permanent versus temporary. That's the
Or, amount of time in the job, level
yeah.
of expertise, even tenure is a valid reason to pay different wages. But
right.
anytime you're looking at being fair and equitable, it's a good idea to have tangible reasons, to your point, that are job related,
Right.
to have differences in pay.
Yeah. And it's now I guess one caveat there. Let's say that we have a job order that says the workers are paid $15.89 an hour, and you have a U.S. worker that's green on that job. They meet the minimum experience requirements, but then you have an H-2A guy that's been there for 10 years, been really good, and on the job order it specifically says that the wages can be, the employer has the ability to increase the wages or provide merit-based bonuses for blah, 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 blah reasons. In that circumstance, technically you could be paying an H-2A worker more than you would a U.S. worker, but the U.S. worker would need at least what was disclosed on the job order.
Yeah, and in that scenario, what I would look at is when you're comparing employees, are they really in the same scenario? So if you did have a U.S. worker who had the same amount of experience, same level of performance, et cetera, then you'd want to be paying at least the same amount as that higher paid person. So this is something we love to do on a spreadsheet and dig deep in and make sure that we're making good, smart, long-term decisions there.
Yeah, that's always a fun one. Okay, you want to?
Yeah, this is a scenario.
Oh, sorry.
Heidi, go back, Heidi.
Go back 2 of them.
Way back.
Go
back.
Right there.
Yes, no.
Oh, one more.
One more forward. Perfect. Stop. This is a scenario that we actually get a lot of questions about, and just if anyone wants us at some point to get deeper on the U.S. recruiting elements of the H2 program, this is something that we help employers with every day. So in this scenario, you have an H2A petition that was approved, and you've already hired 40 out of the 40 positions that were approved. So your visa workers are here, they've already started work, and they're in the state of Oklahoma in this scenario. And they've been there for a few weeks. The H2A petition 50% mark is 2 weeks into the future, so that hasn't been hit quite yet. So in this scenario, Waldo, who's a resident of Arizona, applied to your job posting and meets the minimum skills, experience, and other qualifications that were indicated on your ETA 790, your job order. When you asked if he required visa sponsorship, he said that he was already authorized to work in the US because he has a green card. Waldo says he will need a bus ticket to Oklahoma and will need housing and transportation, just like in your H-2A visa employees scenario. So choose from the list below what you think the correct answer is.
Oh man, that Jeopardy music would have been so
I
awesome.
know.
You didn't know that you were going to get on here and be tested, huh?
Right.
Yeah.
The results
They're going to be
really don't mean anything other than it helps you learn, because honestly, when you choose the wrong answer and learn what the right answer is, it helps you remember.
Yeah, exactly.
All right, so it looks like we had maybe a couple takers on A, on B, no one on C, but most of you understood correctly that D is the correct answer. So a couple of things, even though all of your positions are filled, because he is considered a US worker, you still would need to offer Waldo the job, assuming that he does the interview. If you have an interview as part of your process, whatever your standard hiring process is, he goes through the steps and There's no reason not to bring him on board. He meets all the qualifications. Item B, I just want to highlight really quickly because I do hear this. I hear people talk about U.S. workers as far as citizenship, and you do not have to be a U.S. citizen to be considered a U.S. worker. You only have to be someone who already has the authorization to work in the U.S. without the employer having to sponsor their visa. And so anyone who has any form of that type of work authorization, regardless of what state they reside in, would be eligible as a U.S. worker to be in that category. And then no one took C, which is interesting because I do think there are some people who would be tempted to stall a little bit till they hit that 50% mark. Just like, oh, I already filled all the jobs. Now I have to have 41 employees. I really need 40. So yeah, the bottom line is you have to offer the job to Waldo as long as he met all the other criteria that was in the job order. If he accepts, you have to start him right away. Don't drag your feet. Timeliness and documentation of the things that you are doing is extremely important in the U.S. recruiting element. He still needs to sign the ETA 790 work contract, and then you'll buy his bus ticket to Oklahoma and include him in your H-2A employee housing and daily transportation to the work site. So you would essentially make sure you're treating him at least as well as an H-2A employee to our general topic.
There's actually a provision in the regulations specifically about this, and it discusses displacement of an H-2A worker because you are properly abiding by the 50% rule. And you know that one concern that kind of pops up for people is a 3/4 guarantee issue. So am I obligated still to pay 3/4 guarantee to the displaced H-2A worker? And the answer is no, you're not. You're not obligated to do that, but you do still have to provide transportation back home. This is assuming that you actually, I've got 40 spots. I got work for 40 people. My H-2A guy was displaced because I hired this U.S. worker. What do I do with this H-2A guy?
Yeah.
So,
which there's a scenario that popped up in the questions here about what if you only had 40 housing units?
And that's usually where that comes up actually. So
but in any scenario like this, we can definitely talk to someone on a case-by-case basis so that we make sure that the advice exactly meets the scenario that they have. Exactly. And if you had 41 housing spots, I personally would recommend that you add Waldo because let's go into the next scenario here.
Real quick, I want to talk about what that now that the question thing's not really relevant on this, but I do want to go into this a little bit because I've had this argument with the Department of Labor in an audit, and that's always fun. So let's go to the next one because I think it actually ties into the next one.
Okay.
So we'll go to the next one and then we'll talk about it after this.
So you hired Waldo, you did all of those things and brought him in, and he lasted a week, and then he
Waldo.
he absconded on you.
Yeah.
Everyone was looking around saying, "Where's Waldo?"
I was so embarrassed by this show. Okay.
You came up with the joke.
I know.
But
that makes me way more embarrassed.
Okay. But the point is, he didn't last more than a week, and just even though you had told everyone what the job conditions were in the job order, inevitably he just thought, oh, it was hot. And I know you said it was hot, but man, I'm not used to hot work and I don't like being hot, even though I'm from Arizona.
It's cool there.
So as an employer, you feel burned. Like, I paid your bus ticket, I paid for housing, I did all these things and jumped through all these hoops to hire you, and then you're just going to abandon us here.
Yeah.
And so it's very tempting to say, hey, what do we do about this? What did we learn from this situation? So true or false, you've heard from other visa employers that they add experience requirements to their job order to raise the bar on the recruiting and screening of U.S. workers as required under the H-2A visa program. So you've decided to require 2 years experience on that next petition. And hey, that means because Waldo had less than 2 years experience, he had like 2 months. Yeah. You could reject the next Waldo that comes along.
Yeah. Sorry, Waldo.
So select your answer. Do you think that's a strategy that could work?
Keep looking,
or not
Waldo.
So much.
Keep on looking.
you have an answer?
Not yet, but I'm so excited. I'm so excited about it. Oh,
We're
nice.
split, and I
like
was
this
kind of
one.
expecting to be split on this
Yeah,
one.
that was a good one. Oh, nice. Okay. Go ahead. You got it.
Okay.
Yeah.
So I would say that you would absolutely want to consult with your attorney in this situation.
Definitely.
Yes. And I know you can explain all the reasons why.
Yeah.
Some of the ones I'm aware of would be that the Department of Labor might look at, hey, is this the same job that you did last year? Why does it suddenly require 2 years of experience, and last year it required 2 months of experience?
Yeah. Yeah, so they'll look at that, but then there are also the DOL conducts these wage surveys all the time. They assign job codes to different occupations, and with those different occupations, they have the industry average. It's an industry average range of experience, and for H2A positions, it's normally from 0 to 3 months. So if you're going outside of, let's say you're going to 2 years, you have to substantiate to the Department of Labor, why is your job different than everyone else's to where you require 2 years of experience when the industry average is 3 months. So that's and they will ask that. They do that every time because people try the strategy of, okay, well, it's okay to require some experience. But this does actually bring up the point I want to talk about a second ago. And I had this exact argument with the Department of Labor before. So I'm going to give you the circumstance. The employer required 3 months of experience in a particular occupation. I'm not going to go into what the occupation was, but let's just say it was running a combine. So they had 3 months of experience running a combine on the application. There was an accusation of failing to hire an able, willing, and qualified U.S. worker. And the U.S. worker said, hey, I had this experience. The employer who brought H2A people from Mexico actually had someone in Mexico test the proficiency of people to make sure they actually have run a combine for 3 months. And the employee was unwilling to undergo that scrutiny, or the U.S. applicant. And so what the Department of Labor said was, well, you still discriminated against them because they had that experience. And it's like, but they didn't go through the proper interviewing processes. And this works actually both ways. So now let's say that you don't do anything and all you do is ask your potential beneficiaries of an H-2A visa, we'll just say they're from Mexico. All you do is you call and you say, hey, do you have 3 months of experience running a combine? Yes. Okay, good. You're on the list. A U.S. worker calls and says, hey, I have 3 months of experience running a combine. And you say, okay, well, let me see. Yeah. So you can't do that. You have to apply the same standard. You can't be more harsh towards U.S. applicants than you are towards your non-immigrant applicants, and it can't be both ways. So you have to, which is totally fine. If you want to just say, because I've actually had that too, where I had an argument with the Department of Labor where they were saying, but you didn't test their ability. You didn't call their references. And the employer was able to say, I don't do that with anyone. Yeah. And the Department of Labor at one point was saying, well, that's not enough. And then they ended up coming around saying, okay, well, no, that's actually true. But yeah, just make sure that whatever standard you're applying towards determining eligibility based off work experience, you're applying to both. And then, as always, document. So I have this new H2A worker. He met the 3 months of experience because of this, that, and the other. But I have a U.S. worker and I call them and they don't meet the experience, make sure to indicate why on both forms, and always keep forms for that because that's very, very important in an audit. And
I think too, the other thing I see come up with this is the drug testing and background checking can be part of the employer's general hiring policies and practices. And so it's really important in the beginning that they put on the job order whatever the policy is and apply. I know we've facilitated all kinds of drug testing and criminal background checks in other countries. And so sometimes you have to get a little bit creative, but as long as you're being consistent with what's on the job order and consistent with your practices in the US, then it's good.
That's perfect. Yeah, which that's a great point, because it can be, luckily you know how, but it can be tricky to get drug testing done and background checks. Those things are really hard internationally, but they're not that hard here.
Possible.
So so sometimes people want to do them for the people here, but they'll neglect to for their foreign applicants. So.
And that's not fair.
Yeah, exactly. So Department of Labor doesn't like that. They consider that discrimination against U.S. applicants. So, okie doke, you can go on.
So the next topic, are there any questions we needed to address?
No.
Okay. So the next topic is the 3/4 guarantee. And this is a topic that comes up frequently when we're talking to employers, is questions around this, because different scenarios will crop up. And so we've come up with several scenarios that I've certainly seen happen, so that we can address them more specifically. But as a general rule, the 3/4 guarantee, you would come up with that number by looking at the start date on your petition, the end date on your petition, and what was the schedule that was promised. So is it 45 hours a week? Which days of the week are affected? So, is Saturday in the mix or not in the mix? Sometimes that can influence it when you're looking at just which day of the week it starts and ends. And the other thing is the federal holiday. So you would want to extract any federal holidays from that time range because they're not required to be included. And then if the employee has a Sabbath, then that can also be excluded if they're saying, I can't work on that particular day, and that's part of the work schedule.
Yeah.
So
one quick thing.
Yeah.
So the other, I guess, so yeah, you calculate it based off of the later of the start date of the application.
That's
or
right.
The worker's arrival. So sorry, just a little caveat.
You're 100% right. Yeah. If they don't get there, if they don't start till a month in, then that first month would not count.
Because Waldo displaced them. They had to come
right. And Waldo was a little late to the job, but that's just based on the timing of his hire. So, and then the other thing is, so you would take that and multiply that by 3/4. But it's really a dollars-based calculation. So even though here in the formula we're showing it based on hours, I think it's good to start with hours, and that makes the assumption that you're paying exactly that wage that's promised on the job order. But if you do pay a higher wage to that individual because it's allowed on the job order and you had a reason to do so, or you paid bonuses, sick time, things like that, any additional compensation would be factored in towards what the employee earned as it relates towards that 3/4 guarantee and the minimum amount of money that was guaranteed.
Right.
So we have a lot of great tools and best practices around doing actual calculations. But I think with these scenarios, we'll be able to cover some scenarios that we see a lot.
Yeah. Always fun.
So the main scenario is the same for all of these, where the work schedule on the job order is Monday through Friday, 7 a.m. to 5 p.m. with a 1-hour lunch. So it's a 45-hour work week. There are no hours posted for Saturday and Sunday. Due to weather conditions, however, there were several weeks during the contract period when the work couldn't be conducted on a weekday. However, workers were able to make up the hours missed on the weekend. So in this particular scenario, Mario declined to work the makeup hours on Saturdays and Sundays. So do those count as hours offered but not worked?
Yeah. Specifically because he declined them. That's what complicates this question.
Absolutely.
And I've actually seen the Department of Labor go with counting those hours, but it does appear, if you actually read the regulations, that those would be excluded. And so I don't know if that's the Department of Labor's inconsistency or if that's just the enforcement of it. But the strict interpretation of the language of the regulations would indicate that those will not count towards it. But I have actually seen the Department of Labor count those hours in audits before.
The nice thing is it's a very rare scenario because most employees want to earn as much money as possible. But in any very specific scenario like this, absolutely you could pick up the phone and talk to one of us and make sure that you're weighing all of your options because there's that potential for some risk if you do count those hours.
Here's a good question. What if an employee has to go home
To their home country? Oh, we've got that one covered. But yeah,
we have it in here?
Yeah, we have a scenario that covers that.
Perfect.
So so we're gonna pause on the question we just got and
but it was an excellent question.
It's an excellent question because we hear about it a lot. So going to the next scenario. So same work contract and everything. Clara, who's one of the employees, opted to work every hour offered and was able to work more than 10 plus hours on work days as well, without the rain. So again, she's working beyond that normal schedule of the 9 hours a day and make up all that time on Saturdays and Sundays. So true or false, the makeup hours she worked may be counted toward her total hours worked when calculating the 3/4 guarantee for Clara.
Yes, awesome.
Yes, we have the poll right here.
This part's so exciting.
It's more fun,
It's
right?
way more fun. I want to click on one. Like, I know the answer.
I hope you know the answer.
Remind me in a minute, another fun topic to talk about is what happens if they work way more hours.
Oh, yes. I think that's a great topic to cover as well. Do we have our poll results? Oh, you guys are so smart.
Yeah, that's good.
True is the answer. It would be confusing sometimes, right?
Yeah.
Based on what we talked about with Mario.
Yeah, do those count? Especially, she didn't get to, I guess this could probably make it a little bit more complicated. What if she didn't get to work for a full week because of weather? So over the course of that pay period, she didn't meet her 3/4 guarantee.
Oh, it's not a per pay period calculation. It's over the course of the entire contract.
Yeah, and a lot of people always are like, "Oh man, they didn't get their 3/4 guarantee this week." It's like, that's not the way you look at it. You look at it over the duration of the whole work contract from the later of the date of the start date of the application or the worker's arrival. So, okay, cool. And then let's talk real quickly about
exceeding hours by quite a lot.
Yeah. So the Department of Labor thankfully issued a little bit of guidance on this. So it is considered a violation of the H-2A regulations if the number of hours disclosed on the job order and the number of hours on average actually worked by employees has a deviation of 20% or more, or more than 20%. Sorry. So I disclose 40 hours on average. My workers are working 60 hours a week. The Department of Labor comes in and investigates you. They would consider that a violation, and their justification behind that is, well, if you would have said that on your job order, a U.S. worker for sure would have wanted to work those sorts of hours, which I think we all know is usually not the case, but that is their justification for it. Now, let's say that you do say, on average, they're going to work 50 hours a week, and they end up working 55 hours a week. No issue.
Well, and I think the other thing, Kyle, sometimes is the question that the Department of Labor would raise is, how did you come up with this number?
Yeah.
And if it was, hey, it's always been that average and we didn't use that average, then that might be an issue. But if the prior year, it was an average of 40 hours, but there were some extenuating circumstances that push it over the edge, then I think you could have some math that Kyle could help you talk to the Department of Labor about.
Yeah, I'd be more than happy to. That's always the fun part. So, that would definitely be a mitigating factor in determining the severity of the violation. Okay.
Okay. What is the next scenario here? So this is going to go in line with the question that we have propped up related to people going home to their home country. So I'll pose the scenario here, and then we can kind of talk about the other scenario in conjunction with it. So same work contract, same set of employees. In this case, Sam was injured, and he was placed on total temporary disability by the workers' compensation doctor for 3 weeks. So he's not allowed to work. During those same 3 weeks, the crew was able to work the regular job order schedule without weather or other issues. So during the 3 weeks that Sam wasn't allowed to work due to his workers' comp injury, do the hours that were offered to the other workers count towards hours offered but not worked in this scenario?
So count towards the 3/4 guarantee.
Exactly.
Yeah. Okay.
Yeah. Where this is a mitigating factor.
Yeah.
Yeah.
It's
Got that pop-up window. I know, it's like I'm waiting for
I
the
always
results of something.
I know. Every time I always hated true false whenever I was taking tests because I was so bad at them. But that's probably because I didn't know the answers to this.
I am not surprised that this is split, because I think throwing in a workers' comp element to this can be confusing. And I feel like because there's multiple elements of compliance involved, it feels very complicated.
Right. Yeah, it does. But they do count as hours offered. So was it 20 CFR 655, 122 K and L, I think, have broken out the different reporting requirements, or recording requirements, I should say, for workers. If you can also Google that, and I can tell it to you again in a second, but it has the pay stub requirements for employers. I think L specifically is the one with pay stub requirements, and it has broken out separately for this exact reason: hours offered versus hours worked, because you are calculating the 3/4 guarantee based off of hours offered. That's the important part.
Yeah.
So
not just exactly,
Yeah.
not just what was worked. So this also applies in that scenario that someone posed in our questions with regard to what if an employee wants to go home. And I see this happen often when an employee is sick, and it's not in a workers' comp scenario, it's a personal, let's say, illness, or their mom is deathly ill and they need to go visit her. Really looking at that as like a leave of absence that you're approving does come into play, because those hours will continue to be offered. So again, looking at the actual schedules of your other employees that are in the same team, or the same work job order, and comparing that and taking credit for those as you do your calculation would be important, because this person could work those hours, but they have a reason not to work them, and,
Right.
and it's a personal reason. It's one that's driven by them.
Yep. Those hours are still offered regardless of the situation.
Absolutely.
Yeah.
And one of the things that employers absolutely need to do, though, is track and document when people are missing work.
Yes.
So if they call out sick, if they're like, hey, I stayed up too late last night, I
Yeah.
broke up with my girlfriend or boyfriend last night, or whatever the scenario is, but they're saying I can't work today, you want to have documentation of that. And when people are on a leave of absence, you'll definitely want to have a good, this is the last date they worked, this is the first date they requested off, here's the last date that they requested off and then they returned. Certainly in that scenario, if the employee goes home and they don't come back, you're going to want to make sure that you are filing your absconder report and doing all of the other elements of letting the Department of Labor and USCIS know that they didn't return.
Yep, exactly. Yeah. But yeah, that is it is very important. Again, I know it's probably annoying to hear us say document everything, but we mean that quite literally. I don't care if you have a court reporter following you around all day typing what's going on, but it is important to document, and that is also an important reason to check the regulations to make sure that your pay stubs are consistent with them. And yeah, I was in case you didn't write it down, because I was talking pretty quickly. The regulatory citation, it's 20 CFR 655.122 L. And if you just scroll down to L, it'll say all the hours and earnings statements.
Yeah, and that's one of the things that we look at a lot when we do compliance audits for clients, is making sure that their wage statements are compliant, and they're behind the scenes tracking that they're supposed to be doing from a payroll perspective.
Yeah. What if you don't have hours offered on your payroll stub? Well, one nice thing is Kiersen can help you fix that.
I can.
So where those are on your hours and earnings statements moving forward. But let's say hypothetically that you don't have them now, and you're in a Department of Labor audit. Department of Labor audits go back ordinarily 3 years from the date the audit's initiated. Usually what they do is they can look at it one of two ways. They can actually just say, okay, then you didn't say what your hours offered were, so we will assume the hours worked were the hours offered. That's the ordinary way that they approach that. If, for example, they don't do that, they don't have they have some other justification. The other ordinary justification for it is actually looking at the hours worked on average by all the employees. So they'll take the cumulative average, say that's how many hours there were, and they'll use that as a 3/4 guarantee. But if you don't have the hours documented, and then some employee falls below that 75% mark, then that's kind of an issue that you're going to have to weed through during a Department of Labor investigation.
Now, there's other things that are required on the wage statements that often aren't automatically put on them.
Right.
The other thing is timesheets or timekeeping records, if they're available to the employee, can count. So if the employee either has access through a timekeeping app or your HR payroll system to see what their hours were relative to the timekeeping, having the work schedule posted in there and being able to compare that, or the total hours that they were scheduled to work versus what they actually worked, can be combined with the pay statement on the payroll front.
Yes.
And be considered statements that you gave them. So it doesn't have to be one document. It can be multiple sources of information, as long as those are provided to the employee at least by the time they're getting paid each pay cycle for that pay cycle.
Yeah. And so and you can a lot of people like to still hand deliver or mail the pay stubs, which can be really burdensome or expensive. But there are ways to actually digitally transmit them to the employees that are compliant with the H-2A regulations. And you just have to be pretty specific about your process. That's another thing that Kiersen can help you out with, though, if you do have that come up.
Definitely.
It looks like I think that our things.
All of our scenarios are complete.
Okay. Well, we did get a question here. Oh yeah. Okay. So sorry, this question was just a couple of minutes ago. I just didn't see it beforehand.
That's a good question.
Are you allowed to give a bonus to some H2A workers, or if you give one, must you give it to all the workers? So it's all dependent on what is disclosed on your job order. So if your job order says, which all of our job orders do say that because our clients like to have that ability. So we'll say merit-based bonuses can be given, higher wage rates can be given. The important thing from your perspective, assuming that that's disclosed on your job order, so let's assume it's disclosed on your job order, then the important thing is that you document why you gave that bonus or why you gave that higher wage rate, because that's something they're going to ask you about. And believe it or not, in 3 years, you might not remember why you gave that bonus. So
yeah, documentation, again, being very important. But definitely anytime you do for one, but not everyone, having not just the documentation of where the bonus came from, but the reasons for that is key.
Yeah, exactly. Okay,
Kyle, that is one thing I've noticed when we work with employers who maybe used an agent to obtain their visas. I often see that they have very little flexibility on the pay front, that they're often stuck paying that AEWR rate. They have no room for bonuses, no room for pay increases. And so definitely, I think that's a differentiator that I see from the law firm.
Thank you. Yeah, no, we definitely pay a lot of attention to what's on the job order, because that's the first thing that they do in these audits is they say, okay, let me have all your filing documents. They'll go through your filing before they talk to your workers to see if it's consistent with, or what your workers say is consistent with your job order. It's the easiest way to fine you for an ungodly number of things that are otherwise irrelevant. Like we have in our job order, we also specifically mention, this is the process for firing someone. So they can go through the process for firing someone if you want to fire someone, because what you don't want to happen is for a H2A worker to come around saying, hey, they didn't fire me for anything. They were just running short on work, and so they fired me, so they wouldn't have to pay their 3/4 guarantee.
Ah, yes.
And I've seen that happen quite a few times. So it's important to document, and make sure that your documentation is consistent with your job order.
Yeah.
So, okay. Were there any other 3/4 guarantee issues?
Let me real quick. Here.
Oh,
Is there another one? No, I think
No, we're
Sam
done.
was the
Okay.
last one.
awesome. Well, do we have any other questions about anything we talked about? It's also fun.
I do feel like we did a good job of nerding out on this today.
Oh, I think we definitely have. Yeah, no, I think we definitely have. Yeah. Yeah, no, it is interesting. It's always interesting to, yeah. So someone posted a comment about their organization doing this for 13 years and always including that. And I guess that they're probably an agent. But that's true. Like that's not to say that all agents don't do this.
Oh, yeah.
There are definitely good agents.
Mhm.
There's definitely bad lawyers.
Yeah.
So that's not to say that agents don't do that, but I have seen a lot of filings from agents that are just bare minimum
Mhm.
but that doesn't mean that yours are in there. I mean, for your filings could be great and focused on all the regulatory requirements and give some flexibility to employers for all we know. But
Yeah.
No, so that's definitely not to say that it applies to all agents, but it
Yeah.
does apply to a lot of agents.
Absolutely.
Do we have any other questions? Where do I need to go to look at information about bonuses? Go to your job order. On your ETA 790, what you can get from the person that filed your application, you can go under the wages section, and it'll say specifically what's on your job order for proper bonuses, increased pay rates, those sorts of things. So,
And in the absence of information, so if it only has the AEWR and nothing else, then the assumption
is that the
would be that
AEWR is
that's it.
what applies, right?
Yeah.
Yeah. And sometimes it's also on an appendix if there's too much, which I think oftentimes ours are because there's so many details on there.
Yeah.
Cool. Do we have any other questions?
Okay.
3/4 guarantee or housing or otherwise?
Good.
No? Okie doke. Well, if y'all do have questions or comments or want to hear about anything else, we have our emails right there in the chat. Feel free to email us directly. More than happy to help. But thank y'all for participating. Oh, okay. Can we charge for cleaning the house? That is a great question. That whenever you say cleaning the house, was it something destructive or ordinary wear and tear would be the question. So, for example, if they threw a house party where it just went way above ordinary wear and tear, and you need to clean the house for that, and it's disclosed on your job order, then definitely. If it's ordinary wear and tear, such as I need to clean the house because there were 12 guys in this house for the year, you can't charge for that. Okay.
I do recommend though, Kyle, that they check on the housing periodically.
Yeah.
So that you don't have surprises at the end of the season.
Yeah. Yeah.
You can get ahead of them way in advance.
Yeah. That's also another thing the Department of Labor does in audits is they'll go in and inspect the housing again to see if it's still consistent with what it was at the beginning of the year. And the employer can be held responsible for what the employees are doing just because the employer didn't check on it. The employee left their eggs out when they should be refrigerated, because that's a really common thing in Mexico.
Yeah.
The employer can be held responsible for that. They did whatever. And so, yeah, I agree. It is very important to continue to check on the housing all the time.
And take pictures. Document when you went, take the pictures. It's so helpful.
Yeah. I send a cleaning crew in weekly. Can I charge for it? No.
You are awesome.
No, that's not something you can charge for, unfortunately. But it's important for the grower to set clear housing rules. I completely agree with that.
Yes.
At the beginning of your, at the beginning, whenever you're checking in your workers, it's really important to familiarize them with what your expectations are with the housing. So I completely agree with that. I think it should be one of the things that you do upon check-in.
Well, and I think too, Kyle, it's not just about putting it in the job order. When we're onboarding employees for an employer, we make sure that we're covering that information with them. And it's just about setting expectations and communicating what's expected at the very beginning. So whether that's job related or housing related or transportation related, because frankly, I've seen people trash vans as well.
That's true.
So just being very clear about expectations and then actually following through and holding people accountable, even if it's a verbal warning or written warning, is really critical.
Yeah. And that's a great point, because that is something that you can also put in your job order. These are my expectations with the housing. And then they could be subject to disciplinary action if they don't abide by your housing rules. So that's a good thing to include. And then go through upon check-in, go through with the job order, make sure they understand that what you're doing is consistent with that.
Absolutely.
Cool. Do we have any other questions? No?
Aggressive discipline for sure. Yeah. Don't forget to give positive feedback too. If someone's doing a great job, it helps too. Not just the stick, but the carrot to go with it. But I think that's an area I really love to help employers with, is the employee relations, because at the end of the day, your H2A employees are still employees. And so being able to treat them in every other way as you would your other employees is part of the equation. Yeah,
that's true. Yeah, and sometimes it's kind of hard because you're bilingual, and all the people that work with you are. Sometimes it's hard for people that aren't to actually communicate what they're feeling to their workers, especially in a coherent way. And so that's kind of a nice thing to have y'all as an intermediary to make sure what they're communicating is right, first of all, and then secondly, to be able to effectively convey that.
Yeah, the tone and everything really does matter.
Yeah. Okay. Any other questions before we log off here? And this is recorded, so y'all can watch it back anytime if there's anything that you want to go back over.
Well, thank you for inviting us.
Thank you for joining. Yeah, no, it was awesome. We got to do one live for once. That's awesome. I got to nerd out on it with you. That was really great. That's good. Okay. Well, thanks everyone. And we will, see you in about a month. Thanks.